Hello friends, in the series on the income tax cases, today we will discuss a very important issue. When the limited scrutiny case is to be converted into complete scrutiny, the assessing officer has to follow a set procedure. This issue has been decided by Kolkata ITAT B bench in the case of Sukhdham Infrastructure LLP versus Income Tax Officer. This case has been reported in 117 ITR Tribunal, page number 402. The matter has been decided by Kolkata ITAT B bench and the date of the judgment is 23rd February 2023. In the present case, the case of the assessee was picked under limited scrutiny for the assessment year 15-16 and the four issues were interest expenses, income from real estate business, sale turnover mismatch and other expenses which were debited to the profit and loss account. During the assessment proceedings on the limited scrutiny of these 4 points, the learned assessing officer issued notice to the assessee under section 142 subsection 1 asking various information on these 4 points, and in addition to these 4 points, the assessing officer also made inquiry about the secured and unsecured loans and deposits. When this information was sought from the assessee raised the apprehension that the information which was sought regarding the loans and advances and deposit was not covered by the notice of scrutiny which was on limited scrutiny alone, but the assessing officer went away with the additions. So the assessee moved to the CIT appeal against the assessment order. During the CIT appeal also, this was one of the main contention of the assessee, that the additions have been made on a point which was not covered by the limited scrutiny, although in the present case the limited scrutiny was converted into complete scrutiny, but that was after the issue of notice under section 142 subsection 1. The submission of the assessee was that first of all the permission of the Principal Commissioner of Income Tax should have been taken, and then the notice under section 142 subsection 1 has been issued asking the information which was not covered under the limited scrutiny. But in this case, the assessing officer has first issued the notice and then have taken the permission. So he has bypassed the procedure. CIT appeal although deleted the addition, but he does not make any disposal of this ground of the assessee specifically. When the matter was before the tribunal reminded of the instruction number 5 of 2016 dated 14th July 2016, which says that before conversion into limited scrutiny into complete scrutiny, the learned assessing officer should have reasonable view that there is a possibility of understatement of income, and that reasonable view should be on the basis of credible material and not merely on the basis of suspicion and conjectures. The tribunal also said that this reasonable view should be dependent on reliable sources. Tribunal further said that there should also a direct nexus between the information available and the formation of view that there is an understatement of income if the limited scrutiny will not be converted into complete scrutiny. So the tribunal said that in the present case, this procedure was not followed. The assessing officer has not made the reasonable view and he issued the notice first and then he has converted the limited scrutiny into complete scrutiny. So it can be safely said that the assessing officer does not have the jurisdiction to issue the notice under section 142 subsection 1. So whatever the assessment has been done on the basis of that section 142 subsection 1 notice, that assessment is bad in law, that assessment is not legal and deserves to be quashed. The contention of the department that subsequently the case of the assessee has been converted into limited scrutiny into complete scrutiny does not impress the tribunal, because first of all, the case should be converted from limited scrutiny to complete scrutiny, and then the notice under section 142 subsection 1 should have been issued. But this procedure was not followed, and hence the ITAT quashed the assessment proceedings. At the end of this video, once again I am repeating the name of the case. The name of the case is Sukhdham Infrastructures LLP versus Income Tax Officer, and this case has been reported in 117 ITR Tribunal at page number 402. The matter has been decided by Kolkata ITAT B bench, and the date of the judgment is 23rd February 2023. Thank you, friends.